Hi, I'm Dana Brooks of Fasig Brooks, and I want to talk today about tort reform and caps on damages. You kind of start hearing about that every so often, usually right before the legislative session begins. The insurance companies and the big businesses that pay out these claims, they start going to the legislature and asking them to try to make them not have to pay so much in these claims. And so there's a lot of creative things they come up with, and one of them is called tort reform. Torts are just a civil wrong. If you do something wrong that's a criminal action, you could get arrested by law enforcement, and the prosecutor, the state attorney, could prosecute you. And then there would be a punishment. That's a criminal type of a matter. There's also a civil matter, and that could be when someone does something wrong and they cause you money damages, and that's when you come to lawyers like us. We're tort lawyers is what that's called. And tort reform is simply an effort by the legislature, Chamber of Commerce, insurance companies, hospital medical associations, all the people who would have to pay for the damage of their insureds. It's their attempt to limit their damage, meaning limit the amount of money available to pay people who are injured. Our job is to represent those people and make sure they get full compensation for the full extent of their injuries. If someone's going to have to pay a burden for a wrongdoing, it should be on the wrongdoer, not the person who was injured by the wrongdoing. That's the way we look at it, and I think that's the way most people look at it. Responsible people buy insurance, and they do it to protect themselves because we can all make mistakes. We have insurance for what we do professionally. We have insurance. I have it for my home and my automobiles, all those sorts of things. Responsible people have insurance to protect them when they do cause harm to other people. So what we try to do is make sure there's the full value given by the insurance company or the person who did wrong to the person who's injured. But tort reform puts a limit on that, and it's often arbitrary. One of the things I have to explain to people often is that we have an entirely different legislative scheme for medical malpractice cases, which is a specialty of mine. But I have to tell people a lot that if their child dies and their child is over the age of 26 and the child is unmarried and has no children, there's not much I can do about that because of the way the statutes have been written by the legislators. That is something that the parents would not be able to recover on, and since there's not a spouse or children, the children wouldn't be able to recover. Same thing whenever people come to me and they have an elderly parent who dies as a victim of medical malpractice. A lot of times they ask me, what can be done? Well, if the child is over 26, there's no children under 26. If the elderly person is not married, there's no recovery rights for people like older children or brothers and sisters or caregivers or partners, life partners. It has to be a marriage. So a lot of people don't believe that makes any sense. I can't tell you that it makes any sense. I've had cases where the person died and left 4 children. 3 children were over the age of 26, so they didn't have any recovery for losing their parent, even though they had a longer relationship with the parent. So it would be the younger person, just younger by a year, who would get to recover. So it's arbitrary. It doesn't make a lot of sense. So I encourage people to reach out to your legislator. Let them know that the burden for wrongdoing should be on the person who caused the harm, not the person who was injured by it. But we need your help with that. We need you to reach out to your legislators and let them know that they should take care of everybody, not just the people with the money. So I appreciate you listening, and tune in again. Thank you.